And I want you to stand right here, and I just want one or two of these. When you draw back.
Oh, really? The one right there?
Yes, we all put it back.
Yes, hands.
But what we got to do, in any other county. What's how is he? I like him. A long time ago. On what?
Five minutes. 5 minutes. Is road 12 look all right to y'all? You okay? Sherry, you need to change the jury composition on your road 12. On the regular jury, there were 2 African-American males. I couldn't find my list of jurors, but I know Ken Bingham was on it. He was
He was
football
assistant track
coach.
coach or something at
Yeah.
the high school.
Yeah.
And there was a guy that used to work for Sammy.
They have me 2 alternate or 2
No,
regular?
regular jury.
Well, I don't know. I assume they made it through to the end.
I know Bingham was on the case.
I think they both were.
They were the techniques.
I think that's all we did.
I need to change that one.
I don't know about that. I don't think I need to change.
Write the number of jurors.
Creek, Virginia, presiding. Please remain standing. May God bless the United States, state of Tennessee, Hardin County, and this honorable court. Be seated.
Thank you, Sheriff. I'm far enough away, I'm going to uncover a little where y'all can hear me. First of all, we're a little bit over 2 hours late starting. That's what's known as a snafu. Y'all know what a snafu is? Situation normal, all F up. What actually acronym that it stands for. We just had some disparity between the transportation. I told them I got all day. It created absolutely no problems. You folks have been with us throughout the day. I was advised early on in this case, after Mr. Scholl and Brandon got involved, one of you said, Judge, we will not be needing a trial date. And that was fairly early in the process. We were still in Decatur County at the time I was told that. Prior to that, I'd actually said, and this was in Decatur County, we got Miss Nichols with us today, who is the Commissioner of Children's Services, and she was lead prosecutor, which reminds me, I'm going to get Susan Jones FaceTime, because they've been through this case throughout, and I'm going to let them follow it to the end, so I'll be...
Hi there.
Hey, we just started the hearing. I opened court, and we just now started the hearing. I briefly addressed just a few preliminary matters about, I was informed by defense counsel fairly early on, and they didn't tell me something had been worked out. They just said we will not be needing a trial date. And I had said prior to that, we were still in Decatur County. That's why I looked back and saw Miss Nichols, and you guys were both there. You guys, as well as all the other attorneys, were there, and I think you probably remember me saying, if I was involved in this case from a defense standpoint, it would be a race to 201 Poplar. You remember me saying that? And apparently you folks won the race. Then sometime after that, the attorneys got together with the prosecutors. There was a proffer in this case. Actually, Mr. Autry met with attorneys and prosecutors and went through the route of what he testified to at the trial. Is that correct?
Yes, sir.
So we're ready to proceed now. You want to announce the basic terms of this plea agreement?
Yes, sir. Are we far enough away?
You are, I don't know about him, but
I can talk through it. I can sort of.
I can hear you.
Yes,
Make sure the court reporter can hear you.
It's a little hard.
All right. I'll talk as loud as I can. Actually, 3 years ago to this day, Mr. Autry testified in this courtroom and told the jury and I guess the world, as it were, what happened April 13th of 2011. In this courtroom then and in this courtroom today, Karen Bobo, Dana Bobo, they're here.
I saw him earlier.
And they are in support and agreement with this guilty plea, which takes into account the realities of the prosecution before Mr. Autry cooperated, and then takes into account the importance of his cooperation and his credible, truthful testimony at trial.
I addressed earlier at the motion for new trial on the co-defendant. His testimony was some of the most credible, persuasive testimony I've ever heard given in a courtroom.
And it answered many questions that were left open factually in the investigation. It answered many questions that Karen and Dana had about what happened to their daughter, and it was a very important piece in getting justice for Holly. This guilty plea is to 17 CR 10. counts 3 and counts 8 of the indictment. On count 3, Mr. Autry pleaded guilty to the B felony, facilitation, especially aggravated kidnapping, an 8-year sentence as a range 1 offender. Count 8 of the same indictment, he'll plead guilty to solicitation to commit murder in the first degree, a class B felony, 8 years confinement as a range 1 standard offender. The two sentences to run concurrent with each other and also concurrent with a federal sentence which is noted on the judgment sheets. The other counts by separate order are asked to be null pros without cause.
All right.
Mr. Autry will serve the sentence. There'll be no petition hearing or my approach.
Yes. Mr. Autry, can you hear me well?
Yes, sir.
I'm going to go through your rights at this time. You have the right to plead not guilty. If you enter a plea of not guilty, you're entitled to a speedy and public trial by jury or by a judge sitting without a jury. At a trial, you'd have the right to the assistance of counsel, the right to confront and cross-examine witnesses testifying against you, and the right to compel witnesses to appear and testify on your behalf. At a trial, you cannot be compelled to take the witness stand and incriminate yourself. If your plea of guilty is accepted, there will not be a trial, and this case is at an end other than the imposing of the sentence upon you. In accepting this plea of guilty, the court can ask you questions, require that you answer those questions under oath on the record with the assistance of your attorney, and your answers could later be used against you in a prosecution for perjury. You need to understand that if you should ever be found guilty of another criminal offense at a later date, the judgment of conviction in today's case could be used to enhance the punishment for that later offense. You need to understand that by the entry of a guilty plea today, that you're waiving your right to appeal your case to a higher court. I want you to stand with your attorneys. I'm going to put you under oath. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You are Jason Wayne Autry.
Yes, sir.
In case 17 CR 10, it's indicated you may wish to enter a plea of guilty. Are you doing this freely and voluntarily?
Yes, sir.
Nobody forcing you to enter a plea against your wishes.
No, sir.
Do you fully understand what you're doing today?
Yes, sir.
Have you consulted fully and thoroughly, discussed the case fully and thoroughly with your respective attorneys?
Yes, sir.
Talked with them about the nature of the offenses as well as any possible legal defenses.
Yes, sir.
Pleading guilty to count 3, especially aggravated kidnapping. The range 1 offender could get 15 to 25 years, and the charged offense on count 8 is first degree murder. That could be life without parole, or death. If the court accepts your plea, plead guilty to facilitating especially aggravated kidnapping. That's an amended charge, be an 8-year sentence as a range 1 standard offender, 30% classification. Count 2, you'd be pleading guilty to solicitation of murder 1, receive an 8-year sentence, range 1 standard offender, and 30% classification. They will run concurrent. Do you understand what that means?
Yes, sir.
They're also running concurrent with a federal sentence.
Yes, sir.
You want to give me a statement of facts, or does he want to stipulate a factual basis exists?
Your Honor, please, we stipulate that a factual basis exists for the plea. Ask that you accept the negotiated plea. I do want to say one thing for the record that we discussed, Your Honor. There was no formal agreement in this case between defense counsel and the prosecution until about 1 month ago, within the last month. So no offer was conveyed or given to Mr. Autry until just a few weeks ago, when I did so via Skype with the TDOC. So I wanted to get that clear for the record.
No formal agreement, because they would have been, the other co-defendants would have been entitled to that. I think everybody suspected that an agreement would be forthcoming, but no formal agreement was reached until, you say, about 30 days ago.
We did not start having our conversations for the formal agreement until about 30 days ago.
Okay, let the record so reflect. Anything else?
That's all, Your Honor.
All right, yes.
What is he pleading to in count 8?
Solicitation of first degree murder.
Judge,
Yes,
is that not a Class A offense?
I believe it's Class B, or it's solicitations 2 levels down.
solicitation's 2 levels down.
It goes down one, just like facilitation does.
They said they thought solicitation went down 2, facilitation went down 1.
That's correct.
They might want to double check that before they finish.
I think both sides said that they had finished. I'll stick around a few minutes after we recess this hearing, double check and make sure. Mr. Autry, I accept your plea. You're sentenced as I earlier announced.
Judge, it's our intent in the plea for exactly what Your Honor stated. For on the first degree murder, for that to go 2 levels down, and on that kidnapping, especially aggravated kidnapping, for that to go
Goes down
1 level
one.
down. And Judge, we have talked to the TDOC. He has over 2,000 days of credit available. We wanted to make sure that that was reflected on the record, which is enough time that will cover this offense.
So they will essentially enter that into, what is it, Tomas or whatever?
Correct,
And
Your
he's
Honor.
probably got his sentence built.
That's
But they'll
correct.
have to run that through the computer to make sure.
They have to process it, Your Honor, but we have been assured that he will get credit for this, the offense that was in Decaturville, and all the credit over 2,000 days.
Judge, the only question, the only reason I asked Mr. Shull to put that down there is because our case numbers changed. And I don't want any confusion about, you know, where you get pretrial jail credit from which case number, because the case numbers changed. But
Yeah.
it's
He gets
actually on the
pretrial
bill.
credit from the time that the indictment was entered, the first indictment.
At
Correct.
time of arrest. And I think we spelled it out in the judgment sheets, Your Honor.
Okay.
The scenario of how the case numbers changed.
Okay. Mr. Autry, do you feel like you've been treated fairly by the court?
Yes, sir.
All right. I try to treat everybody with dignity and respect.
Thank you.
All right, anything else?
Nothing to say.
As I said, I'm going to recess. Y'all double check and make sure we're where we're supposed to be going on that. And if need be, before they take him away, let's make sure we got everything nailed down, okay?
That's fine, Your Honor.
All right, thank you.
Thank you. All right.
I can, I said, I want to say this is over. He's getting old. He's getting old. He's ready to retire. Y'all can be seated.